Public Safety Committee will come to order. Apologize for our lateness starting here. Another committee was meeting in the room. I need a motion to approve the minutes of Tuesday, March 4th, 2014.
So moved, Mr. Chair.
Representative Rosenthal makes that motion. All those in favor signify by saying aye. Aye. Opposed? That motion prevails. We just have two bills on the calendar today. A bill on the Safe Harbor project, which is 2114-44, which is my bill, and then Representative Simonson's bill. And so I think we'll take for both those bills, since we have a little bit of time, we'll have opportunity to bring us all up to date on the content of not just those bills, but what is happening with the Synthetic Drugs Task Force. And my presenter will provide a little bit of an update. Presenters will provide a little bit of an update on the Safe Harbor program. So, Representative Rosenthal, if you would do the honors here, I'll just do my bill.
Thank you. I'd like to sit across from Dave.
Mr. Chair.
Representative Paymar.
The motion I'm going to make now this is the motion I'm making now, is that House File 2144 be laid over for possible inclusion in the Omnibus Public Safety Bill. There's a chance that we may not have an omnibus bill, and then if that occurs, Representative Cornish will, any bill that has been laid over, we will then bring back up again and refer them to the General Register. But that's the current motion. So that's my motion, Mr. Chair.
Thank you, Representative Paymar. Would you like to move your bill?
Yes, I would move House File 2144. And, Mr. Chair, basically this bill, I have two testifiers from Ramsey County, but maybe even before. Let me explain the bill. We appropriated money to Ramsey County last year for the Safe Harbor program, which is a fairly expansive program that's gone through many different committees. The specific legislation that we passed dealt with training prosecutors, training law enforcement, and training other human service providers on how to deal with children who are being trafficked in a innovative way that is now saying that if children are arrested for forced prostitution, that the county attorney's office will not prosecute those cases, but will instead divert them into services that they need to get out of prostitution. So it's an innovative approach that we want to take statewide, and I think what I'd like to do now is to have my testifiers from Ramsey County give us just a short update on what's happening. We hope to be bringing, we don't hope, we will be bringing this training for prosecutors and law enforcement statewide. I think there's about 20 different trainings that will be held all over the state with an excellent faculty, and a lot of thought has been put into developing curricula, training materials, getting the best possible trainers in the state, from advocates for human rights, Breaking Free, law enforcement in Minneapolis and St. Paul, et cetera, et cetera. I'm actually giving you the overview that they're supposed to be giving you. But that, if the chair and the committee would indulge us, we'll give that overview. Then I'll have Mr. Melton from the Post Board come up and explain the issues with my bill. That's okay.
Welcome to the committee. Could you state your name for the record, please?
Yes, thank you, Mr. Chair. My name is Erica Schumacher, and I work for Ramsey County Attorney John Choi. We are just really pleased to be here today to provide an overview of the statewide appropriation that you gave us last year. We're very honored, we think, to have this appropriation. It's not political at all. There are no opinions about how this money should be spent. And we are working really hard to make sure that we cover all the ground we need to cover statewide with this. So I'm going to have my colleague, Dave Pinto, walk you through the elements that we pulled together for this bill and what our appropriation plan is over the next 2 years. I just want to remind you this is part of the bigger package that you appropriated as the legislature last year. It was $2.8 million for sex trafficking. Our portion of that is the $700,000 that's dedicated to training and protocol development. So with that, I think I'll turn it over to Dave Pinto, an assistant county attorney in our office, who is the point person on this project.
Thank you. Welcome to the committee. Could you state your name for the record, please?
Mr. Chair, Dave Pinto, P-I-N-T-O. I'm an assistant Ramsey County attorney. Mr. Chair and members, I specialize in crimes of violence against women and kids, domestic violence, and then sex trafficking over the past couple of years. You have in front of you, I believe, just a one-page summary of our plans for the appropriation that was awarded to our office last session. As Erica said, want to emphasize, this is part of a broader plan. In the State Department of Health, there's a director of Safe Harbor program and a series of regional navigators are being hired throughout the state, and then also funds for shelter as well. So this is part of all that. In the appropriation, our office was directed, and we put this at the top, to really do three things. To develop a model protocol for folks, for assistance professionals who are encountering those who are victims of trafficking or at great risk of that, and identifying them and intervening with them. Also to develop investigative best practices, jumping to the third bullet, for that same group, and to disseminate those as well. And then to conduct statewide training, and it's focused specifically on law enforcement and prosecutors. So the model protocols and the investigative best practices are for a broader array of groups, and then focusing on the training for law enforcement and prosecutors. And then down below you'll see a series of items explaining how the $700,000, our current plan for how the money is allocated. You'll notice that these figures go to the dollar. It's $507, things like that. This reflects our best figures right now as of today as to how the funds will be spent. And of course, over time, we'll see precisely how those dollars work out. But the first item is a series of conferences throughout the state. We plan to have 11 of them, with a kickoff conference in late April in Alexandria. For folks from a wide variety of sectors. So these are multidisciplinary conferences, and then again following with 10 more conferences after that to get energy and collaboration happening throughout the state. And then a series of other steps beyond that. You can see we're going to be developing model protocol, best practices training for law enforcement and for other systems professionals, and training, and as Representative Paymar said, a series of trainings that we have planned both to accompany the conferences for patrol officers, conferences for investigators, specifically to focus on the best ways to investigate and handle these cases, multiple trainings for prosecutors as well. And then in number 5, we're going to take advantage of the term we've been using as piggyback trainings. If there's a pre-existing conference for folks who are encountering these kids, we want to be there, because if we don't have to fund the setup of the conference, fund the logistics, et cetera, we can simply be there and present. We want to make sure that we do that, so we want to take advantage of that. Our office then has some staff capacity to handle all of this. I think it's important to know that that does not cover the full cost for our office of doing that. And then there's the items at the bottom as well, and that adds up to the $700,000. I think that this does give a pretty good summary, but certainly I'm very happy to answer any questions from the committee. Thank you.
Thank you, Mr. Pinto. Any questions from the committee?
Providing the overview. So to the bill then, Mr. Chair, the
Representative Paymar.
This House File 2144, and if Mr. Melton from the Post Board could come down, this will allow the reimbursement to police departments throughout the state of Minnesota in 2014. So that's 3 lines to the bill. So, Mr. Melton.
Welcome to the committee. Could you state your name for the record, please?
Thank you, Mr. Chair. My name is Neil Melton. I'm the Executive Director of the Minnesota Board of Peace Officer Standards and Training. And one of the primary missions of the Post Board is to coordinate a reimbursement fund for law enforcement training across the state. And that's why Post was included in this language. The way the process has been set up, and we've had meetings with Ramsey County Attorney's Office, is that licensed officers will attend training. They'll sign a roster giving their name, their post license number, and their agency. That will be signed off and approved then by the instructor. Those forms are sent to the Post Board. We approve them, we review them, and then we send a new copy to Department of Finance, and they will then distribute the money to the agencies. So we approve this extension. Anything else?
So would anybody in the audience like to testify for or against this bill? Representative Paymar, I just want to thank you for all your work in this area over the years. You've done a tremendous job, and you've been tireless in your work for this, and you deserve a great deal of gratitude. Thank you, Representative. So I don't know if you have anything else to say. Otherwise,
Just maybe to the committee, if you want to see some progress that's being made on safe harbor vis-a-vis Ramsey County's intervention with their prosecutors and their and police in Minneapolis and St. Paul, and what will be happening statewide. If you want to watch, Carol Levin had a great piece on what Ramsey County is doing and how some of these underage children are being already served through this kind of intervention. So with that, I appreciate your support.
thank you, Representative Paymar. Representative Mullery.
Thank you, Mr. Chair. Either the author or either, I just wondered how this tied into the new Center for 180. Isn't that kind of connected, that the feds are funding? Just real quick.
Real quick, Representative Mullery, the 180 degrees is... Oh, I'm sorry. Yes, I'm sorry.
Okay, go ahead. Proceed.
Thank you. Representative Mullery, to your question, 180 Degrees is currently pursuing funding to build a shelter for youth, to include specifically sexually exploited youth. They're not funded out of this state fund. So just to clarify, our funding is the $700,000 for training. This Post Board is an additional $100,000 for reimbursement for officers.
Mr. Chair, I'm sorry.
Representative Mullery.
I just wondered if I knew the funding had nothing to do with it. I just wondered if they were tied in some way.
Other questions? I will make the motion to lay over House File 2144 for possible inclusion in a public safety omnibus bill.
Representative Simonson, House File 2446. Would you like to move your bill?
Thank you, Mr. Chair, and I would be happy to move the bill if you could tell me the next committee stop.
It will be referred to Health and Human Services Policy.
Then I would move that House File 2446 be referred to the Committee on Health and Human Services Policy.
And Representative Simonson, you have an amendment, or an amendment has been offered, I should say that. And I just saw it a minute ago, and I have no idea what it does, and it did not meet the 24-hour rule. Based on what Representative Lomer has to say when she explains it, and what you have to say as the chief author of the bill, I would waive that rule, and we could discuss the amendment. But I just saw it a second ago, so...
Mr. Chair, however we proceed is certainly your choice, but I will tell you that I'm not opposed to the amendment, and I have talked and spoken with the author of the amendment, and if we don't hear it here today, we'll certainly entertain it at the next committee stop.
Then, Representative Lomer, do you want to wait for the next committee? Or do you think if you explained it, it would be so overwhelming, your testimony, that we would all say, absolutely, let's put this in right now?
Well, thank you, Mr. Chair. That's worth a try in my book. I'd love to explain my amendment if that's okay.
All right.
You want me to do that right now?
Well, yeah, and I guess what I would be concerned, is, I want to know what it does, and then if there are any costs to it, et cetera, so we all know what we're doing.
Sure. Well, thank you, Mr. Chair, and I do apologize for the lateness of you getting to have a chance to see this. We just got it last night ourselves. So anyway, so first of all, I really want to say thank you for the opportunity to be on this synthetic drug task force. It was a great privilege to serve, and I really think that Representative Simonson did a great job. So in regard to the amendment, at our last task force meeting that we had when we were sort of wrapping up and talking about our recommendations, I asked the question of the Attorney General, is there any chance that we could, let's see, how do I explain this? Could we do something about the long-term costs for folks, just thinking about the testimony of a lot of these families, especially thinking about the testimony of the 24-year-old, the mother from Duluth who talked about her son who would be in restraints, permanent restraints for a long-term violent psychoses after taking these drugs. So the amendment would say that someone that is convicted of selling these controlled substances will be responsible for some of the costs rather than having the taxpayers, because that would be likely what would happen. The taxpayers would be paying for these folks for a very long time. So this would just, the court shall order a person convicted of selling a controlled substance to have the legal ability to pay for these costs.
Representative Lomer, so just seeing this and just hearing what you're saying, I don't necessarily disagree with the intent. So who would monitor then this, the offender's requirement for restitution and paying the cost? Would the...
Mr. Chair, I think that would be the court.
So
it would be a court-ordered.
Are you, I don't know, but is this going to make Representative Simonson take another committee stop somewhere?
I don't know.
Or is it going to judiciary? Do we?
Maybe Mr. Diebel would know that.
Mr. Chair, I do not know. I 100% agree with the concept behind this, and if we need to adjust the language going forward to make it more palatable, that's certainly, I think, fine. But I would, refer that to you, Mr. Chair, and to, well, she's not here. But as far as the extra committee stop, I don't know.
Ms. Taken-Holtze says it may have to go to judiciary anyway, so I guess we could still do that. We don't have, Mr. Diebel is saying that this language, can you just, it's incorrect, you're saying the language on, or which?
Mr. Chair and members, the draft that was handed out is a draft of the proposal. The final amendment, I believe it's the A1 amendment, is in your hand but has not been copied. So okay. I would recommend that you wait to take action on it until you have it in front of you. The only difference between the draft and the final version is that public and private entities are entitled to restitution for their emergency response costs. In the draft, it only included public entities, but the final version would entitle private medical providers or emergency service providers to receive restitution for their costs incurred in responding to a synthetic drug incident or medical response to someone who's injured by synthetic drugs.
Representative Lomer, would you mind doing this in judiciary since it's going there anyway, and then we can ask all those questions if there are any financial implications for the court? I just wouldn't want to do it here and then have it to come back here. And would you go right with that?
Mr. Chair, that's just fine.
Okay. I think the intent of it is good.
Thank you.
Thank you. So we don't need to do anything formally with the amendment. Representative Simonson, do you want to explain your bill and maybe take us through your journey? I've been to one of your meetings, and I know several of the committee members here have been on the working group, and I want to applaud you and the working group for all the work that you've done. I know some of your communities have been hit harder than others with the synthetic drug problems. So I'll let you explain everything.
Okay, thank you, Mr. Chair. And since we do have a little bit of time, I'll maybe expand a little bit on my comments. But purposefully, I don't have a lot of testifiers here today. I think we heard a fair number of testifiers last year in this committee, and rehashing that again didn't seem to be necessary. But what we really want to do is get into what's in the bill before you. But I want to thank you, Mr. Chair, for this hearing and for your support of the Select Committee as we went forward after last session. It's very important work here that has been done by members of this committee, and we shouldn't discredit that in any way. But I think an important point to make is that this will be a continued effort going forward. If we've learned one thing about the synthetic drug problem in Minnesota and across the country, is that it is an ever-changing problem. It is a little bit different than typical drug abuse problems that we see and deal with on a day-to-day basis. And some of what's in the bill, I think, will highlight that. But I think it's important that this committee and other committees are going to have to continue to address this and adjust this as we go forward to meet the needs of the market, if you will. What's in this bill before you has been a very collaborative effort. I want to commend the House members from both caucuses for helping with this. I think it was the goal of the committee that we come back with something that was meaningful and that could be supported by both caucuses going forward. I want to thank staff that's been incredibly involved and incredibly helpful. Certainly Mr. Diebel, Ms. Weeks, and Ms. Taken-Holtze have participated in this process from the beginning and have been most helpful, and I certainly appreciate that. And in addition, we've had many agencies, both state and local, that have provided input and important advice as we move forward with this provision. As we know that the work of the committee essentially began in Duluth, where we attended a public hearing with the Attorney General, and the committee members, for the first time, some of them heard very compelling testimony from Duluthians about the impact of synthetic drugs on our community. And that impact varies across a wide range, starting with personal impacts, testimony from victims themselves, as well as family members, and the impact to the family, both on a financial side as well as a health side. We heard a lot of testimony about the impact to the business world. This particular retail shop in Duluth was located on a busy downtown street and had significant impact on the bottom line of adjoining businesses, and it got to the point where folks just didn't even want to walk down that street or be in that neighborhood. That is a very extreme example, I understand that, but I think what's important to highlight is that as the committee traveled more across the state and solicited testimony from different communities, is that the problem exists everywhere. It may not be as visible as it was in Duluth, and it if you think about it, most people that are doing something illegal don't necessarily want to be visible. So we had a unique situation, but what we did learn is that it is very prevalent still in Minnesota, especially amongst student populations, high school, college, as well as young adults. Synthetic cannabinoids and synthetic cathinones have not gone away with the closure of the last place on earth in Duluth. If anything, we've seen a marked improvement in the quality of life in Duluth as that went away and that proprietor went to federal prison. But what we did was shift some of the demand off to neighboring communities where these things are still being sold. So the intent of this bill is really to get at the retail sale of synthetic drugs. And it's not that we don't recognize that there's a significant problem with getting access to these drugs over the internet, but the reality is that there's little that we can do with that right now, at least. So you have in front of you the report from the work of the Select Committee that was presented to the Speaker just ahead of session. And though it's lengthy, it's good. But I would encourage you all to at least read the executive summary, which is only a few pages long. And I think it really kind of tells the story of what's happening across Minnesota, as well as the work that the committee did. Within this report are a series of recommendations that we made to the state of Minnesota in taking a comprehensive approach to further combating synthetic drugs. And there's a number of recommendations that are included in the bill that I'm going to walk through here in a minute, as well as there's a recommendation for Minnesota's legislature and state agencies to continue work with federal congressional delegation and federal agencies to pursue further efforts to control internet sales of illegal drugs. And we also included a couple of recommendations for local governments to consider. I think that one of the things that we all agreed on is that in order to resolve this problem or slow it down or make a dent in it or whatever term you want to use, that we had to use more tools from the toolbox. And by doing that, I'm saying that local units of government can consider adopting comprehensive drug ordinances similar to what's been done in other parts of the state. So within the report there are recommendations for local governments as well as local county attorneys as they move forward with the prosecution of these cases. So with that, Mr. Chair, I think that sort of summarizes some of the work that we've done and the whys and the whos, and then I'll get into the details of the bill if that's all right with you.
Okay, are there any questions at this point? And just also name that Representative Lomer, Representative Newberg, Representative Schoen, and Ward were also on the. Am I missing anybody? And Representative Taken-Holtze for putting this together. Thank you very much. Representative Simonson, go ahead. I know it's a collaborative effort. And you want to explain the bill now?
Yes, and this really is sort of a mini omnibus bill, but it is a very comprehensive bill designed to really focus and take away an opportunity for these retail shops, businesses to pop up in your communities and avoid any of you and any of Minnesota having the same problem that we have in Duluth or having the same problem that's currently happening in certain communities across Minnesota. So I'll just walk through here real briefly, and then I'm going to turn it over to Mr. Weiberg from the Board of Pharmacy to offer his comments, as much of what's in this bill certainly affects him and his board and the work of that board. But Section 1, Mr. Chair and members, essentially expands the current definition of drug. And what we're trying to do here is capture these synthetic drugs without targeting products that are currently legal. It's certainly not our intent to target, Bed Bath & Beyond and some of the products that they sell there. Our entire goal here is to create language that focuses in on these synthetic drugs that are being sold for one particular purpose, and there's no secret behind that. So we expand the definition to include these drugs and compounds that are not regulated by the United States FDA, and they must also induce an effect that's similar to current scheduled drugs. And that gets into the expert testimony piece, which I'll cover a little bit further deeper into the bill. Section 2, and this is really kind of the heart of the bill, if you will, it provides the Board of Pharmacy the authority to issue cease and desist orders to businesses that are violating this law. Now, this is a new piece, and this is an expanded authority for the board, and you're going to hear from Mr. Weiberg here shortly about how he intends to accomplish that. But we think that this is an opportunity for local law enforcement to work with the state agency to gain relief quickly and immediately, even though there may be pending litigation charges, if you will. And I'm just going to give you a quick example. If local law enforcement goes into a head shop or a gas station and they find that what they suspect to be synthetic drugs being sold and what they suspect to be is something illegal, currently under current law they have the ability to make a charge. We collect a sample, we send it to the BCA, there's testing, many months go by, there's courts, there's all sorts of things that happen, maybe several months before there's some resolve. And during that entire period of time, of course, that retailer has the option to continue to sell that product. This provision, if passed into law, would allow the Board of Pharmacy to go in and under their expert opinion determine if that particular product did meet the new expanded definition of drug, and they could they could issue a cease and desist order on that business for that specific product. Now, that's a very important point to make because we're not suggesting that the board has the authority to go in and close down the business. There's certainly legal products that are being sold there, and that's not the issue at hand. The cease and desist would be specific to what falls under this newly expanded definition of drug. And it's similar to current authority that the board has in pharmacies, but I'll let Mr. Weiberg speak to that momentarily. The Section 2 goes on to provide the same notice and hearing rights as current Department of Commerce law, so there's no change there. It's just bringing that into this particular process. And I just want to remind you that, again, the cease and desist is specific to the product, not to the overall business. Section 3 goes in to cover the enforcement of the cease and desist and provides for injunction relief provision, which is consistent with current law in other areas. Section 4 addresses the exception portion of current law. We want to talk about paints and glues and things like that that are sold and bought on a daily basis. That is not what we're targeting here, and Section 4 addresses that. Section 5 brings in this very same language that we've been talking about to the list of prohibited acts. And Section 6 deems a drug adulterated that is manufactured at an unlicensed facility. Section 7 changes the term identity to ingredients, and I think Mr. Weiberg will speak to that, why that's important for him, under the definition of misbranded drugs. Section 8 talks about the Board of Pharmacy and the expedited scheduling. And I want to spend just a minute on this piece because I want to be sure that legislators understand this provision. This is changing what's current law that hasn't been law for very long. But essentially, a couple of years ago, the legislature gave emergency rulemaking authority to the Board of Pharmacy. And that was done to try to capture this quick turnaround and change of chemical makeup, if you will, of synthetic drugs. Some of our last attempts at resolving this problem with our analog laws have been to, as we come into session and there's a new list of things that are being sold on the market and we capture that list of things and we put it into statute as something that's illegal, that's signed into law, and the very next day the manufacturers are back out there and they change the chemical makeup of the drug, thereby trying to skirt around the law. What the legislature did a few years ago to address that is give the Board of Pharmacy expedited rulemaking authority to capture those ingredients and make them, covered under the rules and not having to wait for the legislature to come back into session to do that. And one of the provisions of that law was that when the legislature did come back into session, that they had to ratify that change by the board. Otherwise, if they didn't ratify it, it simply went away. Now, this change, or this proposed change in Section 8, would remove the requirement for legislative ratification when the board, by rule, would add a substance to the current Schedule 1. And that is a topic that we discussed at great length, and again, you will hear testimony from Mr. Weiberg why he believes that this is a good move, and I certainly support it. I think that in this particular case, this is an opportunity that the Board of Pharmacy has limited rulemaking authority, limited in scope in terms of what they're overseeing. And I want to just remind us that we always have and retain the authority to change law. So it's not like if something was done under their rulemaking authority that the legislature couldn't undo that if they chose to. So that is one particular piece, and I'll encourage you to listen to Mr. Weiberg about that as well. Section 9, 10, 11, 12 really get into some dollar issues, and some of which I don't have answers to yet. Our goal in this committee was to come up with something that was effective, that could be supported by both sides of the aisle, and spent as little money as we possibly could. For the purposes of this committee, we don't have a completed fiscal note, but I do have a preliminary fiscal note from the Department of Public Safety that has a $0 impact. So consider that as we move forward. There are other provisions that I'll just touch on, even though they will be heard in other committees. We have appropriation to the Attorney General's office to train prosecutors and compensate expert witnesses. And this expert witness is a piece that I touched on early that I also want to come back to now if I can. There was a case recently in northwestern Minnesota where a successful case where somebody was charged and convicted of sales of synthetic drugs. And it really came back to the testimony of the expert witness. And when we talk about, expanding this definition of drug and including particular substances that are not regulated by the FDA, and we say that they have to, when ingested, have a similar effect as current Schedule I drugs, you really need somebody that can come to the stand and testify to that. Because you can imagine that there's some vagueness to that. And that particular case in northwestern Minnesota, I can't remember the county, might have been Baudette, not sure, ended up with a successful prosecution because of testimony provided. So this provision, what we would do is provide hopefully a small amount of money to the AG's office where these expert witnesses could be developed and compensated for their time when they go to testify. Section 10 would be an appropriation to the BCA if they needed one for analyzing and testing, which we know now we don't. And Section 11 really gets into another important provision of this bill that I'll just touch on because most of it will fall under Education Committee. But what we want to do is a provision of this omnibus bill is provide an opportunity for new education to be introduced, especially to students, okay, middle school, high school, potentially into college, about synthetic drugs and their hazards. Because if there's one common theme that we heard as we went around the state and talked to, just families and individuals, is that A, they don't know anything about it, they don't know what it is. B, there's this conception out there, or perception I should say, that the term synthetic marijuana is very misleading. Okay, they think because the term marijuana is used that it's relatively harmless, and the fact that the term synthetic is used ahead of marijuana makes it even less harmful. So there's a lot of misinformation out there, and we spent a lot of time with the Department of Health, DHS, and Department of Education trying to come up with something that we could use to get better information out early and, just kind of expand on our current drug awareness. Again, we're not searching for recreation of the wheel here. What we want to do is bring this into the current discussion about drug awareness, drug prevention, and drug abuse efforts. So there may be a small amount of money that we have to do there. But this has been complete collaboration with Department of Health, DHS, and I will say that DHS and DOH have been extremely helpful and are actually working right now to try to finish a project in-house where they're developing a specific website about synthetic drugs. Because that's one of the pieces that we've always been missing is you can Google synthetic drugs and you're going to get all sorts of information that you really don't want or need. But we're providing one unified source of good quality information from the state, and they're in the process of doing that now. And the last section would have been an appropriation for the Board of Pharmacy to enforce cease and desist, but I think it's important to keep in perspective that I'm not anticipating that the board will be out doing these things every day, all day, forever, right? I mean, this is going to be a fairly limited application. Hopefully, as the message gets out and the word gets out, that it'll be needed even less and less. So that kind of covers the contents of the bill, Mr. Chair, but I'd like to hear some comments from Mr. Weiberg, if you'll allow.
Representative Simonson, before we get to Mr. Weiberg, I have one question on the bill, on Section 2, and I part of the questions to Mr. Weiberg, but the first one's to you, because I guess I don't understand the full authority that the Board of Pharmacy has. But the question to you would be, in subdivision 2B, it talks about whenever it appears to the board. I don't see anything about law enforcement in the bill, although you testified that if a police officer suspected that someone was selling synthetic drugs, whatever, regardless of the chemical compound, that they could petition the Board of Pharmacy in some way, and a cease and desist order would then take place. So I guess the question is can anybody do this? If it's not in statute that law enforcement is the only entity that has that authority, could I walk into a store and say, I think the owner of this store is selling a synthetic drug, and then notify the Board of Pharmacy? So I guess the question is, who can initiate this?
Sure, and that's a great question, Mr. Chair. And the answer to your question, in simple terms, is anyone could initiate this complaint to the board, essentially. The language that you're referencing here is what happens, after the board investigates, and when it appears to the board that that person is engaged or is about to engage in, et cetera. I reference law enforcement because that's the way that I would envision it would typically happen, is that if law enforcement is dealing with a retailer in their jurisdiction, this is one tool that they have available, that they would have available to them, is that they could reach out to the Board of Pharmacy through the process and request that the board come and investigate that. It's not my intent that the Board of Pharmacy go around investigating gas stations and head shops. I don't think that they have the resources to do that. I just don't think that's a practical approach, but I do envision, and testimony by Mr. Weiberg can confirm or deny this, but I do envision that anyone that had a complaint could make one to the Board of Pharmacy, and I'm assuming that they would follow up on that. But the language itself is about what happens after they put their eyes on it.
So, Representative Simonson, did the Select Committee address that issue at all, about or talk about any unintended consequences or having anybody make those claims to the board?
Yeah, we've had discussions about that, and I think it's important that we didn't want to limit who could make a complaint or an inquisition to the board. We want to leave it open. However, we think from a practical sense that the people that will be complaining will typically be law enforcement. We think that if Representative Paymar walks into a store and he has a suspicion that something's being sold, we think that your normal reaction, if you're concerned, will be to call the local law enforcement, at which point in time they would respond and they would investigate, and then they would use the tools that they have available to them. We don't think that practically that you would, A, know that you could call the Board of Pharmacy and initiate that, or B, that would be something that would come to the mind of the average person. But perhaps Mr. Weiberg's testimony will clear that up for you. But we didn't want to limit it to only requests from law enforcement, and that's why we didn't address the actual request itself.
Okay, very good. Any other questions of the author before we turn to Mr. Weiberg? Mr. Weiberg, welcome to the committee.
Mr. Chair, members of the committee, I'm Dr. Cody Weiberg. I'm the Executive Director of the Minnesota Board of Pharmacy. And I think maybe I'll just address your question, since that just came up before I go through the bill.
Okay.
The Minnesota Board of Pharmacy, obviously state agency, it's a health licensing board. All the health licensing boards are governed not only by their individual practice acts, but also by Chapter 214. Which is a general chapter dealing with all licensing that's done by state agencies. So in 214.10, 214.103, the board is already statutorily obligated to investigate any jurisdictional complaint. And so we get 150 complaints per year. Most of those actually are from the general public. Most of those, of course, at this point, deal with our licensees and registrants, so pharmacists and pharmacies typically. However, in something of an analogous situation. There have been instances where drugs that would require a prescription in this country have been imported from other countries and sold in shops. You may all be aware or have heard of the action taken by the police, the St. Paul Police, the Food and Drug Administration, and other agencies at the Hmong Marketplace, in which they were selling a substantial number of products they should not be selling. The board has received complaints from the general public about the sale of those sorts of drugs as well. That same section of statute basically says that the board cannot dismiss any complaint without at least 2 board members agreeing to dismiss the complaint. So we have a whole process in place internally for investigating complaints, determining which ones are truly jurisdictional, and if we do in fact investigate a complaint and we find that the allegations aren't substantiated, we have a committee that consists of 2 board members. I'm in attendance, so is the deputy director, so is an assistant attorney general that works with us, and those complaints that turn out to be essentially we can't substantiate the allegations, they end up getting dismissed. If we can substantiate the allegations, then we take appropriate actions based on what we're allowed to do in the statutes. So that's sort of how our complaint process works. So we're very used to getting complaints from the public. I will also say, to confirm what Representative Simonson has said, in this particular area, most of the information that we have received has been from law enforcement. And law enforcement will contact us and tell us that, they have seized a product and sent it to the Bureau of Criminal Apprehension for analysis and determined that there's a drug in it. So in this particular area, most of the information we do get is from law enforcement. So.
Thank you. Do you want to, I know I interrupted, that wasn't part of your presentation, or might have been part of it, but did you have some testimony you also wanted to provide about the bill? Or?
Certainly, I can provide just a bit of testimony, a little bit about how the process occurred. As Representative Simonson mentioned, the Attorney General herself became interested in this issue and held a hearing up in Duluth. I was one of the persons that was invited to talk about that. Subsequently, I worked with members of her staff, attorneys on her staff, actually on this language for cease and desist authorities. So this language actually largely comes from the Attorney General's office and is modeled, I am told by them, after similar authority that the State Department of Commerce has. However, we are not a cabinet-level agency, so I do not have the authority myself to directly pursue legislation. So I bring this sort of proposed legislation before the board itself at one of its public meetings. So the Board of Pharmacy itself, the 7 members that constitute the board, who are directly appointed by the governor, have vetted this language and authorized me to support it and pursue it. The cease and desist authority would complement existing authority that the board has, and actually it's important to change the definition of drug. We think that we could use the current definition of drug and assert that these products that are being sold are drugs, but the Attorney General's office and the board have agreed that adding this extra definition, or this tweaking the definition of drug, should make it crystal clear that these products are actually drugs. And that's important because it's already under Chapter 151, which is the Pharmacy Practice Act, in the Drug Distribution Wholesale Act. It's already a crime, just a misdemeanor, but it's a crime to sell drugs that are either adulterated, which means the meaning of that is, it has several meanings, but one of that is it's not manufactured in approved facilities, and of course these products are not. And the other crime under 151 is to sell a misbranded drug, or a drug that's not labeled appropriately according to state and federal law. And these drugs are not labeled in that way. In fact, they're labeled quite deceptively. And so and the other authority the board already has is to enter any business establishment in the state in which drugs are held for sale or distribution. And we already have that authority. So Changing the definition of drug makes it crystal clear that these are drugs, so that we would have authority to go into the head shops and any place else that sold these. We'd have ability to determine if the drugs are misbranded or adulterated. If they are, what we could do right now under existing authority is to embargo the drugs, which is to essentially provide the owner of the business with paperwork saying that they're not allowed to sell the product until either the board or a court allows them to sell the product. But then the onus is on the board to go to district court within 60 days to get an order of condemnation. And at some point we might do that. The cease and desist authority is additional option that the board would have to actually issue a cease and desist order, in which case the onus is on the other party to go to district court and show why we should not have issued that order. So we might end up using either option or potentially both options. So this just gives us one more option to deal with the situation. And then in Section 5, in addition to already making it unlawful to sell adulterated and misbranded drugs, this again then specifically in the new paragraph 15 talks about these products and says it's illegal to sell those products as well. In addition to them being misbranded and adulterated, it's just simply illegal to sell these particular products as well. Then I think I'll move on to the expedited rulemaking authority. The reason for doing that is...
Mr. Weiber, can I just ask what the penalty is? I'm just, what the penalty is for selling misbranded or adulterated drugs?
The penalty for most violations of Chapter 151 is simply a misdemeanor. But the idea here isn't really, I think, to go after the criminal penalties. It's to be able to issue the cease and desist order and basically tell these businesses that they cannot sell the product. And the hope is that, as Representative Simon sort of alluded to, is that we actually won't need to take a whole bunch of these actions because these businesses have to invest money in buying these drugs. And the hope is that if they pay for the drugs and we prevent their sale, that they're going to lose the money they've invested in it, plus the court could order them to pay for the destruction of the drugs as well. So that's the real intent here, I think, is not necessarily to bring criminal prosecutions, but to stop the sale of the product.
Can I just ask Representative Simonson, and if I'm treading on a criminal investigation, just tell me, and I won't ask the question about your specific situation in Duluth. If this law would have been in place a year ago, 2 years ago, what would it have meant to the last place on earth, if anything?
Mr. Chair, I think that's a great question, and I think I could answer it in such a way that I'm not jeopardizing anything. Essentially, what happened is that the last place on earth was open for business during the entire period of time, I want to say 18, 24 months, something like that, while this process played out. Even to the day that the owner of the facility was in federal court, that business was open and selling synthetic drugs. Now, I think to get a understanding of what that means is that this is a business that had $6 million in gross sales in one calendar year. Pretty significant amount of sales. We believe that had this provision been in place, that the cease and desist order could have been issued very early on in the process, and we would have stopped the sales of synthetic drugs while the remaining criminal charges in those cases played on. But at the very least, we do believe that it would have stopped the sales of those synthetic products very early on.
Very good. Thank you. Mr. Weiber, do you want to continue?
Mr. Chair, members of the committee, the expedited rulemaking authority. The reason the board is interested in having this authority, and actually the board, this is another instance where actually some legislators had talked about having this, and the board agreed that it would be a good idea, And the legislators wanted this, I think, after we explained the process that we tried to go through when we first became aware of synthetic cannabinoids several years ago. When we became aware of that, we already have the authority in Chapter 152 to add drugs to the schedules, to move drugs out of the schedules. The only thing that we can't do with schedules right now is to take a drug out of Schedule 1 unless the federal government has already taken it out of Schedule 1. Otherwise, we can add drugs to Schedule 1, which would make their sale and possession illegal. So we invoked that rulemaking authority when we became aware of the synthetic cannabinoids. What had happened is, under a normal rulemaking process, if as few as 25 individuals request it, we have to have a hearing before an administrative law judge. So we went through the rulemaking process, and we had over 100 individuals actually request a rulemaking hearing. It was very clear that, to me at least, I think it was very clear that the intent of these individuals was more than likely not to offer any real testimony as to why the board should not do this. It was to really delay the process. And the reason we believe that is it was also quite clear that this was a very organized attempt because almost all of the rulemaking requests had exactly identical language. So none of it asserted any reason why the board shouldn't do this other than requesting a rulemaking hearing. They were so identical that everything was identical right down to the misspelling of my last name. And so this happened in December. So at that point, the board withdrew those rules because the legislature was already talking about putting these drugs into the schedules in statute. So this is really to be able to do this process. Now, what I will say is with the expedited rulemaking process, you may not have to have a hearing before an administrative law judge, but there is still ample opportunity for public comment. There are still public comment periods built into the expedited rulemaking process, and the board still, because we're not a cabinet-level agency, the board itself has to approve or authorize staff to go ahead with the rulemaking process, and we always have additional public testimony there as well. So there's still ample opportunity for public testimony, but this would make it so that we don't have to go through the through a hearing before an administrative law judge. In terms of, I think the last thing I would talk about in terms of the appropriation, I actually just talked with an assistant attorney general about this, and the board and the attorney general's office, I and the attorney general's office will talk about the fiscal impact. Our primary costs, we think, are actually going to be whatever we have to pay the attorney general's office to represent us in court. We already have 7 inspectors or surveyors, and we have no intention of hiring any additional staff to do this. Any additional work they do in this area, we would not charge that against this bill. So that's why we need to work with the Attorney General's office really and what we're going to have to decide is some estimate of how many times we might have to invoke the cease and desist authority and actually go to court and what those costs might be.
Any questions? Representative Simonson, just on page 8 of the bill, do you, since there appears there is no cost to the BCA, at this stage, do you want to just leave the bill as it is, or do you want to delete Section 10 from the bill?
Mr. Chair, I think if you will allow, I would just as soon delete Section 10 and clean it up as we move forward.
Let me just make sure we're doing the right thing here. Representative Simonson, let's just leave this in for now until we'll deal with Representative Johnson.
Mr. Chair, Representative Simonson. I appreciate all the work you've done. Overall, it's being in law enforcement background, I understand the need for something like this. The ability for these chemists that have been making these synthetic drugs, just changing one element in the drug to bypass our state statutes. One concern I have, and I like the idea of the cease and desist order, I think it could be very helpful, but the question I have is this order going to be given before or after testing of this product? Because if it's a perfectly legal product and you give a cease and desist order, it could be 60, 90 days, 120 days before we find out what that chemical is and who's going to make up the difference to that company selling or that small mom and pop shop that is selling these. And it could affect their bottom line, and it could affect possible employees that they have as well. Although if it's dangerous, it should be out of there. But we really don't know if it's dangerous or not until it is tested. And that comes back to the testing, who's going to be doing the testing. If it's BCA, then there's some cost to BCA. So it affects Section 10 as well.
Thank you. So we'll just leave all this in for now until we get some better information. So there's blank appropriations in the bill. So, any other questions? Is there anyone from the public who wishes to speak in favor or in opposition to the bill?
Mr. Chair, was there a question in Representative Johnson's comments there?
I wasn't sure.
We'd like to answer it if there.
Oh, okay. Representative Johnson, was there a question? Or?
I think so.
The question was the chemicals going to be tested before or after the cease and desist order?
Representative Simonson or Mr. Weiber?
Mr. Chair, Representative Johnson, that's actually a really good question, and I'm rather than try to give you my rudimentary explanation, I'm going to ask Mr. Weiber to respond to that.
Mr. Weiber.
Mr. Chair, Representative Johnson, the intent would be to have it tested first, probably by the BCA. I certainly can't speak for the BCA about why there wouldn't be a cost, but I can speculate. It might be just as we're not going to put any cost for our surveyors going out, they may not feel that they have to add any staff or any additional testing equipment, and they'll just absorb it in their cost right now. But we would have it tested, and most likely by the BCA.
Representative Johnson.
Thank you.
Any further questions? Representative Newberger.
Thank you, Mr. Chair. I just want to take a minute to thank Representative Simonson for all the work that he had put into this. I have firsthand experience professionally with my line of work dealing with this. And for those that are caught in this, it is an unbelievable nightmare from which many people never wake up. This is a specific problem that is costing us the lives of our loved ones, our young people, and I applaud the work of the Select Committee, and it was an honor to serve with the people that were on it.
Very good. Thank you very much. Any other questions? Representative Lesh, are you leaving? Just 1 second, if you could just stay for 1 second, because I have an announcement I want to make sure that for next week, that you're involved in. Do you have any closing comments, Representative Simonson? Or?
Very briefly, Mr. Chair, I just want to correct the record. I misspoke about the county that had the recent successful prosecution. It's actually Roseau County. And I just want to make sure that the appropriate county gets the appropriate credit, because that was a great job by them. But beyond that, I would just encourage support for the bill, and thank you for the opportunity.
Okay, and thank you for your work here, Representative Simonson. Do you want to renew your motion?
I do. I renew my motion that House File 2446 be re-referred to the Committee on Health and Human Services Policy.
Very good. Any discussion? All those in favor?
Aye.
Opposed? That motion prevails. Before we adjourn here, I just want Representative Lesh, because you have I think you have a few bills. Representative Johnson has a bill We're having on Tuesday hearings on sort of data enforcement privacy. We have 2 drone bills. And I just want to know approximately, do you all know how long this is going to take? Because I want to hear all 5 of those bills on Tuesday. And if we can't hear them during our allotted committee time, are people okay with coming back at 6 o'clock?
Well, Mr. Chair,
Representative Lesh.
I'm more than happy to come back at 6 o'clock. They can be complicated issues, especially in light of what's gone on in the interim. And I don't know how many questions members of the committee are going to have. So I'll be as quick as I can on mine. But I can't, I don't know how long. I don't know what kind of questions. My presentation won't go over my lifetime, Mr. Chair.
And Representative Johnson, do you know, Representative Khan has a similar drone bill, I think. I'm not sure if it's the same as yours, but...
I do not know what I'm not sure about Representative Khan's, but with mine, it should not take too long. I'm waiting to hear if I have one testifier or not.
All right, well, I'll try not to make us come back at 6, so, okay. Any further discussion? Meeting's adjourned.